This is Advocate Lucinda, your empowerment lawyer. Last week we talked about the EEOC charge, and we said that once the right to sue letter has been issued, you have 90 days to file your complaint in federal court. Now we're going to talk about the complaint today, but before I show you how to complete it, I want to make sure that you have certain information. One, you want to know your facts real good. Two, you want to identify the issue or issues or the problems. And three, you need to know what law is involved. And I call this the 4 W's. You need to know who, what, when, and why. So let's get started.
Who? Who are you suing? Who discriminated against you? Who violated your rights? It could be an individual. It could be several individuals. It could be the company that you work for. Now, it is possible that you don't know a party that you intend to sue. And you could still include that person as John Doe, but make a great effort to identify who you're suing. What law has been violated from the discrimination that you experience? You must be able to identify the law. Remember, we talked about the categories in which a person can be discriminated against based on their race, sex, religion, disability, age, national origin, color, and some others. But you need to identify the discrimination and the law that supports your claim. For without it, you don't have a case. So you must identify the law. When? Give the court and the fact finders a timeline of the events that occurred in the discrimination activity. You may not know every date, but you need to be able to articulate, write a timeline that the court can follow, and it should be logical and reasonable and fair for the court to determine what it is you're attempting to convey. Why did the employer discriminate against the employee? You must be able to articulate clearly why. Now, you don't necessarily need smoking gun evidence. You can prove the why through what we call circumstantial evidence. In other words, you produce evidence, actions, activity, conduct by the employer show that they were not honest with regards to their reason for terminating you. No, it was not because of a poor job performance, but it was because of your disability, for example. And you can prove that through circumstantial evidence. For example, to show where the employer has been dishonest in the past, where the employer has begun to discipline the employee after they complained about misconduct on the job. Those kinds of things are called pretext. And if you dig enough of that information up, you can survive what we call the motion for summary judgment. But that's down the line. Okay, so next week we are going to continue with the complaint, and I'm going to actually show you how to complete it. On the following page, you will find a list of the videos that I have done that will get you caught up to where we are now. All right, thank you. We'll see you next week.